This is Attorney Margie Brunelli, and today I'm going to continue with the series of videos on construction lien. And today I'm going to talk about the rights of contractors, subcontractor, and material suppliers to place a lien on private real estate property located within Florida if you provided either labor, work, or materials to improve that property. So as I mentioned in the prior video, I prepared written material because it's a lot of information and I don't want to forget anything that's important. So bear with me a little bit. I never read on these videos, but this one is an exception. So one thing that I've noticed, a lot of people get confused and they think that they lose their lien rights if they do not have a written contract. That is not true. You do not need to have a written contract in order for you to have lien rights on the property that you provided either labor, work, or materials to improve. So that's a mistake. Do not let that keep you from putting a lien on the property in case you do not get paid. However, there are steps you must follow in order to be able to place that lien. You have to comply with all the deadlines of the statute. The statute is extremely strict. So I'm going to try to summarize that part of the statute. One thing you have to notice, one requirement, you must be licensed. If the work you're providing or the labor you're doing on that property requires a license in Florida, you must be licensed. If you're not licensed, you do not have the right to place a construction lien on any property. So that's the most important aspect of it. And as to the written contract, of course, we always recommend that you have a written contract, but that is not an impediment to placing a lien. The need for a license is. So preferably, of course, have a written contract because it's going to make everybody's life so much easier. But if you don't, that's not an impediment. So a few things that you need to comply with. You have to give a notice to owner. So what is that? It's just a document you prepare, preferably with an attorney. I do not recommend doing any of this on your own because you need to know where to record it, the time frame, the deadlines you have to follow. So the statute requires that you serve the property owner with a notice to owner within 45 days of furnishing labor and or materials to the construction project. It's 45 days, not 46 or more. So you have to comply with that timeline. So there are a few exceptions. Individual wage laborers, architects, engineers, or other design professionals, they're not required to do the notice to owners. Who has to receive this notice? So if you're hired directly by the general contractor, you send the notice to the property owner. If you're hired by a subcontractor, send the notice to the property owner and the general contractor. And if you're hired by a subcontractor, you're going to send the notice to the property owner, the general contractor, and the subcontractor. Also, you have to file the construction lien within 90 days from the last day that you perform work on the property. So you have to record it. You have to record that, and you have to know where to properly record it, and that can differ from county to county. So it's not as straightforward as you may think, and if you record it in the wrong place, that's going to be a problem. So you must record your mechanic's lien within 90 days from the last day that you provided either labor, services, or materials to a construction or renovation project. There are exceptions to that. I'm not going to go into them because it's going to get too detailed and too complicated. But if you have any questions regarding any part of this video whatsoever, you can always contact me. All my information is above on the bio. Another thing that's also very important to notice is the deadline to enforce your lien. So, of course, the lien is not valid forever. You're not going to put a lien on somebody's property and it's going to stay there forever and ever. No, it's valid for a year. So 1 year from the date that it was recorded. Once that year lapses, the lien expires unless you filed a lawsuit to foreclose on the property. So the whole purpose of the lien is really to resolve the fact that you were not paid. And if you're unable to resolve that with the property owner, the general contractor, whoever is involved, you can foreclose on that property and get paid that way. Of course, the property owner is not going to want to lose the property over an amount of money that's significantly less than what the property is generally worth. So it's a way for you to have a remedy at law to recover for work that you performed, work, labor, or materials you provided and you didn't get paid for. It's not as simple as I'm saying, because with construction, there are a lot of issues involving, okay, I did the work, but sometimes the quality, the work is not up to par, it's not quality work, the materials are not performing to the standard. It can be a number of things. So it's not as straightforward. It's more of a gray area than anything. That's why I always recommend you inform yourself with an attorney before you do anything. Now that period of 1 year can be shortened depending on what the property owner does. And I'm going to get into that in the next video when I'm going to talk about the rights of the property owner. Let me see if I missed anything. So a few mistakes that I've noticed, people that file construction liens, a few things that I'm going to point out. So it's either the failure to timely serve the notice to owner, the failure to serve the notice to the proper parties, failure to serve the notice the proper method, overstatement of the amounts due. That can be a felony, so be very careful with that part of it. Failure to respond to sworn statement requests, failure to timely file a claim of lien, failure to provide a copy of the claim of lien, and failure to foreclose the claim of lien within 1 year. So just to conclude, filing a construction lien requires careful attention to avoid any potential pitfalls along the way. Many times lieners, the person filing the lien, are aware that the time periods have expired, that notices have not been given in compliance. Do not file your claim of lien anyway to try to intimidate the property owner or contractor into paying you. The consequences of these actions may include liability for attorney's fees, damages for his lender of title to that property, and in extreme cases, even criminal liability. Like I mentioned, there's a criminal statute regarding, charging way more than what it's due to you for either work, labor, or materials supplied. So be very careful. You have to follow the statute. You have to follow the law. It's there for a reason. If you have any questions, you don't know how to do it, you don't know where to start, call an attorney. It doesn't have to be me, but don't try to do this on your own, because the chances are you're going to mess this up. So I have another video that's older, also about construction liens. I'm going to try to link it down under this video so you can have access to it as well. I hope this was helpful, and if you have any questions, the phone number here is 954-474-7703, and my website is www.brunelli-law.com. Thank you. Until the next video.